The Supreme Court of Canada has ordered a new manslaughter trial for a man accused of killing an Indigenous woman in 2011. But many who have been following are hoping that the Canadian justice system is put on trial for the way it handled the case. I have to warn you, some of the details in this story may be disturbing to some viewers.
You shouldn't be able to cut up women's body parts for justice. It's not the price we pay.
Cindy Gladue was a Métis mother of 3. She was found dead in a bathtub in an Edmonton hotel. Gladue had engaged in rough sex with the accused, a man named Bradley Barton, who was found not guilty of manslaughter. Gladue bled to death from a wound to her vaginal wall. But what is troubling many is the way that prosecution went about proving their case. A preserved piece of Gladue's vaginal wall was presented as evidence in court.
Not one of the judges even addressed that issue. They all ducked it. And to my mind, that is very disturbing. It allows the criminal justice system to continue to use Indigenous women's body parts as evidence. It allows the state to continue to cut up women's bodies and serve them up on a platter that somebody calls justice.
Gladue was working as a prostitute at the time of her death and had agreed to a sexual act the night before she died. Barton argued that everything was consensual, including the act that led to her death the second night they were together. Details of the story sparked protests across the country. The Supreme Court ruled that Gladue's sexual history was mishandled in the original case that found Bradley Barton not guilty.
I think it's a step forward that the court has recognized that in cases of sexual assaults involving Indigenous women and girls, that there's an obligation on courts, on judges, to be gatekeepers, to ensure that bias, prejudice, racism and sexism do not form part of the evidence.
Judges ordered a new trial for Barton, but voted in favor of manslaughter charges rather than first-degree murder. In Ottawa, Nigel Newlove, City News.